January 1st, is New Year's Day. So we would move that meeting anyway. So let's plan on moving that meeting to the week after. Yes?
Actually, there's 5 Wednesdays in January, so it could actually be.
Say it again?
There's 5 Wednesdays in January.
Yeah.
Could do the 8th and the 22nd, for example.
Yeah, or the 29th. Remember me?
Just one cautionary note on Tuesdays, and that we used to meet on Tuesday, and then one of the major reasons we changed is that it conflicts with Board of Supervisors meetings, and a lot of members of the public, pointed that out to us, and the reason we changed to Wednesday is really to accommodate that.
Got it.
Oh, yeah, we do Tuesday.
So the Board of Supervisors every Tuesday? Okay. So we'll just do it Wednesday, see if we can get the room Wednesday, January 8th, and then Wednesday, either the 22nd or the 29th. We can keep it on that same day. That's better, right, for everyone? And then if anyone, not necessarily? Okay, so Wednesdays are, okay. So let's just see what days the room is available, and then we'll move from there. Okay, for December and January.
Since
Yes.
we raised the concern, Deputy City Attorney Lee, how are we on time and budget for nodded in the...
Holding a second meeting?
If we have a second meeting that would require your attendance until 9 o'clock, are we,
Great.
We don't
Yeah.
have to do
for
that.
the moment?
Great, for a couple of extra meetings for now, and then we can worry about that.
Okay.
Great, thanks. Okay, so we will add this, you will look into that, and we will move forward on that. There's no vote or anything about this, so I'd like to move to the next item on the agenda, which is regular comment. I'll leave you to say that. And I'd like to get, regular public comment. And Madam Clerk, can you put 3 minutes on the time? Thank you.
Members of the Task Force, Ray Hart, Director, San Francisco Open Government. I was in the military for 12 years, and I worked with the federal, state, and local government in Hawaii for another 14 years, but I don't go in for gobbledygook. The 3-minute rule. If you study the open government laws, such as the Sunshine Ordinance, the Brown Act, the California Public Records Act, and if you also go into some of the legal decisions that are issued resulting in cases relating to those, one of the themes you find that goes consistently through all of them is that laws, rules, whatever it is, are to be interpreted in a way that provides maximum access to the public. I would like to propose, since it's been mentioned a couple times already tonight and in previous sessions, that the reading of the ordinance be considered in this way. A member of the public may have up to 3 minutes to speak. That is, to me, a reading that I may choose to speak for 1 minute, I may choose to speak for 2 minutes, I may choose to speak for 3 minutes, because that is my right under the Constitution of the State of California and the United States to decide how long I want to talk. It is, on the alternative, not the position of the body to determine the extent of my constitutional rights and my ability to exercise them. It is very convenient to read something in a way that you say, oh, well, good, I can cut this down to 2 minutes. I can cut this down to 1 minute. I can cut it down to when we get to 5 seconds, and you say, oh, well, that's never going to happen. Yeah, I said it when the Board of Supervisors went to 2 minutes, that very soon other city bodies would start to follow suit and restrict public comment to 2 minutes. I think you must consider the fact that in all the law relating to open government, it has been made very clear that the readings are to provide maximum access. And this law says a speaker shall have up to 3 minutes. And I read that, as I said before, as I can choose to talk for less than 3, but I can have up to 3. That's what the law says. And that's pretty plain English reading in my book. And for the bodies to turn around and say, oh no, what that means is we get to restrict your First Amendment rights under the Constitution of the United States. or under the Constitution of the state of California is an egregiously bad reading, especially when every member of these boards and commissions takes an oath to support and defend the Constitution of the United States and of the state of California.
Good evening again, Patrick Monatshaw. If this body is not already aware of lawyer Alan Grossman's victory in Superior Court against Mr. St. Croix, you should rapidly become aware of it. In part, because Mr. Todd David blatantly appears on audio tape of the August 7th Sunshine Task Force meeting, in which he says, quote, "And I'm kind of the mind that if, you know, the city attorney is elected by the people of San Francisco, and if they disagree with his interpretation of the Sunshine Ordinance and the state of California's Constitution, he can be replaced." That is brazenly arrogant. That is no justification for deciding whether there's a catch-22 between what the city attorney advises city departments such as Rec and Park that you will be hearing on agenda item 4 tonight. Mr. Grossman proved that you don't need to replace the city attorney to challenge the city attorney's ridiculous advice to city departments. You can march into Superior Court if you have the time
and the money,
the resources, and the money. And you can beat Mr. Herrera at his own game, member David, in Superior Court. You don't have to wait for an election in which Mr. Herrera has no opponent. When you face conflicts between what the city attorney is wrongly advising city departments and language in the Sunshine Ordinance, you should bear in mind that members of the public who do have the wherewithal and the resources to file Superior Court cases could easily file one against you, Mr. David, or against you, Chair Grant, for restricting the 3-minute public comment period. How would you like a Superior Court judge ruling that your personal biases are interfering with voters' rights under Sunshine Ordinance?
Thank you. Is there any more public comment?
Hi guys, my name is Paula Danish, and there's a complaint that's pending before you, the Clark brothers, and I just want to tell you personally what was done to me. My permit, street artist permit, was revoked illegally 3 separate times in the course of 15 years. I was not served properly the first time. I didn't even know about a hearing. I did everything within my power to make it known. I spent $10,000 in legal fees fighting the city attorney's office in what was my First Amendment right, my rights under the California law and the Brown Act. I recall even James Chafee went in at one point to hand an application years ago. It's almost 20 years ago the first time my permit was revoked illegally. I got a de facto appeal, which is how I got the permit back the first time. The second time was pretty much the same thing. I believe it was in 2003. I was denied due process, even under the laws of the street artist program, which are very vague, written by Howard Lazar, and not available to the public, or they weren't at that time. So The second time I won on appeal, finding no legal basis for them to have denied my permit. And the third one, as you know, was this past year in a retaliation attempt, simply because I filed sometime complaints before this committee. I am still being retaliated against in the street, which is why I almost never work. So, from personal experience, I can tell you that when you have one person who's been in the same job for 41 years, who basically bends the law at his own will and uses legal opinions or advice from the city attorney's office to disguise or to not give over information, it really it has affected me. The first two times I went before the Board of Permits and Appeals, I felt I was a bad person or a bad artist, or I'd done something wrong. That's not true. It's just been Lazard bending the rules. Thank you. Thank you.
Good afternoon, task force members. Stop the corporate rape of our public library. Don't get money from the library. Don't accept money from the library. This is now the second part of a three-part presentation, and my graphics reflect the actual documents. On September 19, I hope you know that the California Fair Political Practices Commission in Sacramento found city librarian Luis Herrera guilty of 3 years of violations for failure to report gifts. These are the laws that are designed to prevent those who are supposed to represent the public from representing the interests who give them money instead. In order for the society to